Hello and welcome to this Landlord Voices video. My name is Dean Taylor and I am a lecturer at the University of Hertfordshire. In this very short talk I will be introducing you to a recent phenomenon in English housing land law which raises some interesting doctrinal questions as well as some interesting policy and regulatory issues. And that centres around the concept of property guardianship. So we'll be exploring in this very short video how property guardianship has become a part more formally of English land law's schema. But first, before we begin, and to help you to think about these issues, have a look at these three pictures and imagine, if you will, that you have complete run-of-the-mill of these properties. The first on the left shows the interior of a church building. The organ and projector screen are still intact, which raises some issues of fixtures and fittings, but that's for another video. As you can make out in the video, you can see a sofa and a bed. You've got the carpet laid down on what looks like a former church sanctuary, no longer being used for a gathering worshipping community. The second picture in the middle is of a warehouse from the looks of it. The warehouse floor with the sofa in the background, an exercise machine towards the foreground, and another carpet laid out on the floor, and a very interesting use of some wooden pallets suggests that this is a communal area. And then the ancillary rooms off to the right hand side have got the curtains drawn, suggesting that they are used for private dwelling. Finally, the third picture is of what looks like two former business units located just down the road from where I live here in southeast London. One was a bakery, and it may not be possible to make it out, but the other unit, fully boarded up, has the MoneyGram sign above it, suggesting that it was a newsagent. Do these images of these properties shout out home to you? Probably not. But all of those properties will have a sign on them, like the sign here on this slide, making clear that while they may appear empty and that the purposes for which they were once used no longer being used, they are actually being occupied, and those occupants will be guarding the property. Guarding the property against what? Guarding the property against squatters, vandals, which is a likely risk if any property lies empty. And so what is very interesting is how the initial purposes for which these buildings were erected has come to an end. But we know that land use undergoes constant change, and our built environment may be unrecognizable from what we once knew. And it's between the ending of the initial use and the anticipation of what will become that has given rise to the phenomenon of property guardians. Those people who will be living in what would be vacant property, but living in that property until such time as the new use, the new purpose for that land comes into being. And the arrangement with property guardianship looks typically like this. We have the proprietor of the land, so the owner of an estate in land, needs to protect their investment, pending its wait for redevelopment, and of course pending that wait for redevelopment. There is the risk that squatters and vandals will come onto the premises, and of course if there are squatters, then there will be the need to initiate proceedings to recover possession of the property. And so to minimize the risk of that occurring, the proprietor licenses management of the premises to the guardian company. The guardian company will manage the property, and the guardian company, these companies are specifically incorporated to provide services to owners of estates and land, and those services are provided on the ground by the living guardians, by the property guardians themselves. So how this business arrangement works is that the guardian company, as the manager, charges a fee to the proprietor for managing the property. The guardian company in turn charges a license fee to the property guardian to occupy the land for the time being. And largely what we are concerned with is how the occupier actually occupies the land. What is the status of the guardian? And it's this relative relationship as between the guardian company and the guardian which has given rise to some contemporary issues in the courts that we're going to be focusing on in this short video. So some history and some context for you. Property guardianship has been around in England since the 2000s, usually in urban areas. So a few slides ago there was the former church, the warehouse, the former business units. Other examples of property guardian property include residential care homes, which have since closed, local authority office buildings being used for living guardian purposes, former pubs, former police stations, effectively where properties use for an initial purpose has come to an end, then pending that redevelopment, whether demolition and or refurbishment of the premises, then it can be used to temporarily accommodate these guardians. But the origins aren't from England. They originate in the Netherlands in the 1990s, where in the Netherlands property guardianship is an accepted alternative form of housing. Some of the major players, certainly here in England, include VPS, Global Guardians, Low Guardians, DEX Property Management, and Camelot, as was. It's now folded as a company and has now wound up. But one of the interesting dynamics to all of this is that property guardianship has sprung up as a phenomenon because the ideal property relationship, that of owner-occupation, is now more difficult to obtain. So some of the structural developments which are affecting this ability to attain the ideal of owner-occupation include the fact that demand for housing far outstrips supply. And that's before we even get on to prices. And so property guardianship has developed as an alternative form of housing, characterized by much cheaper rents than would be payable in the private rental market, and for living in some very interesting spaces. Which are typically larger than you would obtain if you were renting in a traditional manner. The issue of property guardianship is that even though there are cheaper rents, property guardianship does symbolize some issues to do with lack of security in a wide sense. Typically speaking, the demographic of those who live as property guardians are young people, and indeed those who may be in more precarious forms of employment. And so we think of the gig economy, in which employment is more precarious, lacking in security. And that is matched in terms of housing, where property guardianship is a form of accommodation, but a form of accommodation that lacks security, and has given rise to a theoretical framework in which precarity is emblemized by this form of living. And as it's emblemized by this form of living, we do need to consider where this fits juridically. And so the process has begun in terms of thinking about where property guardianship sits within land law. While land use and human geography, the draw towards the city, for which housing supply needs to be met with ever-inventive needs and ever-inventive fashions, gives rise to some interesting legal questions. So while the built environment undergoes constant changes to reflect the changing nature of land use, legal questions, our status question in terms of the guardian, that abounds. And very interestingly, Gray and Gray have suggested that there is no moment in any day where the individual is not somehow affected by land law, and for which then property guardianship represents a form of living which until a few years ago was pre-legal. That is, that there was no formal adjudication of the status of these property guardians. But recent developments illustrate how guardians find themselves now placed within landlords' need to categorize, classify relations with / in property. And one of those categorizations or classifications, a classic classification, is the dichotomy between the lease and license. And is this dichotomy that property guardians find themselves caught between. We have two cases, two relatively low-level cases that have begun to look at this. And so we have Camelot against Roynan in the Bristol County Court in 2017, and Camelot against Koo in the High Court in 2018. The facts were similar across the two cases. Essentially, the occupant, Roynan and Koo respectively, were arguing that they were assured short-hold tenants, thereby able to rely on the minimum notice period of 2 months for recovering possession of the property. And the argument was that, notwithstanding that the agreement between the guardian and the guardian company in both Roynan and Koo described these guardians as licensees, they were assured short-hold tenants. And the argument was, as put by Roynan and by Koo, that because they were assured short-hold tenants, the notice that they received determining the occupation, so seeking to recover possession of the property, had not been served in accordance with the law. But in order for this argument to succeed, in order for Roynan and Koo to show that they are assured short-hold tenants, they need to show that they have they possess exclusive possession of the spaces that they are occupying within these guardian properties. And the first thing is that Roynan is obviously and immediately subject to the caveat that it's a county court decision, it's clearly not binding, but what is interesting as between Roynan and Koo is the treatment of exclusive possession. Whether it exists is illuminating, but the decisions between these two cases are contrasting. So where does that leave property guardians? In Roynan, the county court held that the occupant, the guardian, was a tenant. In Koo, the High Court, Mr. Justice Butcher, held that the occupant was not a tenant, but a licensee in accordance with the agreement. While there is a need to keep to the broad social policy in seeking to protect the tenant, Roynan does, however, seem to treat the existence of exclusive possession as something that arises solely on a factual basis. And this in turn raises some questions as to whether de facto exclusive possession is enough for a tenancy to exist. The non-performance of the typically little to no notice inspections by the guardian company did not actually take place, and so this led to the finding of exclusive possession by default rather than the right being conferred upon the occupant, as is contained within the speech by Lord Templeman in Street and Mountford in 1985. It should not necessarily follow that non-performance of a term automatically means that the agreement was a pretense, and that's what the county court found in Roynan. But then, what will it take for there to be the genuine denial of the right of exclusive possession? Should not the written agreement be the starting point? Not all who grant permission to occupy land cynically make use of the license label. However, there is a tension between a more paternalistic approach in the private sector compared to the public sector, for which a greater degree of vigilance is required in the former rather than the latter. In Koo, a broader exercise that sets the arrangement in its wider context underpins the reasoning and therefore the outcome. If the agreement between the landlord and tenant creates a contract, and then, where applicable, an estate in land, and that's thinking about Bruton against London and Quadrant Housing Trust in 1999, then this provides an opportunity for the court to look at the relevant background against which the agreement was made in order to assess the intentions of the parties as to the sort of rights created between themselves. Such a pragmatic approach would see the touchstone of the true effect of the agreement being shaped prospectively by what the parties themselves concluded, rather than depending on the subsequent factual performance looked on retrospectively as assuming the thing necessary to be proved. And so accordingly in Koo, the purpose for which property guardianship exists is to provide temporary accommodation until such time as the property is redeveloped. In order to facilitate this, it was felt best to grant licenses to guardians rather than tenancies. The difficulty lies in finding some way through the thicket of dualities. There is at once the tension of pragmatism versus principle, and how that plays out as between commercial parties compared to domestic living arrangements, and then even in the latter, the domestic living arrangements, what approach is taken in the public versus the private sector. The latter where there may be a greater risk of exploitation, and so greater need for the law to provide adequate protection for the occupier. As I say, Roynan and Koo are fairly low-level decisions, and so we await some clarity at appellate level to really get a sense of the question of law that needs to be answered here, which is, are guardians, property guardians, tenants or lessees? Another question that needs to be asked is whether these premises are fit for human dwelling. There have been some horror stories in terms of guardianship experiences. There have been numerous newspaper articles. Interestingly, property guardianship is something that relatively recently has become the subject of academic attention. And even then, legal academics are behind the curve in terms of devoting attention to this phenomenon. Human geographers have looked at property guardianship, and we're only sort of getting in on the act based on these cases that have addressed this issue. But some newspaper articles refer to the fact that property guardians find themselves living in premises where there is a lack of running water, a lack of smoke detectors, a lack of safe fire escapes for the safe departure from these premises. And all the more important given, as Professor Sue Bright has referred to in her video, the safety of buildings after the Grenfell fire disaster. All the quirks of living in property guardianship properties, the large spaces, the cheaper rents, can turn rather quickly into a nightmare. The minimum standards by which someone should be able to dwell have been remedied in part by the Homes Fitness for Human Habitation Act 2018, which amends the Landlord and Tenant Act 1985 by implying a covenant that the landlord is under a continuing obligation to make the premises fit for human habitation. And this seeks to improve standards by putting landlords under an obligation to keep their property in good condition and empower the tenant to take action against the landlord where the property is defective. However, do you notice the catch here? This protection is available to those who are tenants. If Coup is correct, if Camelot against Coup is correct, and the guardian is indeed a licensee, then there is the double whammy of not having a minimum notice period, nor will they be able to take action against the guardian company for providing defective premises to dwell in. Given the need to prove the status as a tenant to be able to enforce statutory duties / obligations, property guardians continue to lie in a precarious grey area with little security. It may be that Coup is defensible on doctrinal grounds, but if the social policy of the law seeks to bring housing standards up to a minimum and give people the notice they need to find new accommodation, then this surely should not be something that rests upon fitting within the fine lease license dichotomy. Too many years ago now, 2006 to be exact, the Law Commission suggested reforming the law so that those renting property as their home, and that after all is what property guardianship involves, albeit temporarily, should be regarded as assured short-hold tenants, and so able to rely upon a minimum 2-month notice period. These proposals were said to take a consumer protection approach focusing on the contract between occupier-grantor rather than depending on status. However, these were never enacted. And so years down the line, new phenomena have sprung up, property guardians. But regulation sadly has not kept pace. Guardians are guarding the property. The guardian company and the proprietor are getting a good deal. But what property does the guardian themselves have? Who is guarding the guardian? I hope this short talk has given you a flavour of some of the current issues in terms of urban housing and how doctrinal questions require answering, but also the policy/regulatory issues that have arisen as a result. Thank you for listening and good luck with your land law studies.